Hello and welcome to 60 Seconds with Sergio, special edition. I am your host, Sergio Cabanas, attorney at law here in Florida. Thank you for joining me today. Today's question is, Sergio, I'm attending a final hearing in a divorce case in Florida, and I understand that I will be required to testify. But what should I expect and how do I best prepare for this hearing? First, let's understand what exactly is a final hearing in a divorce case. Well, in order to finalize your divorce case after a settlement agreement, judges usually require that at least one of the spouses, usually the party filing the divorce, attend a simple court proceeding known as a final hearing for an uncontested case. If one of the spouses is seeking to change his or her legal name, that spouse will be required to attend the hearing in order to achieve this name change. This is an important hearing which allows the judge to review the legal documents in your case, including the marital settlement agreement and parenting plan if there are minor children, to decide whether the divorce case is legally eligible for what's called a final judgment. A final judgment is an important legal document that formally terminates the marriage and incorporates the terms and conditions of the settlement so that the agreement becomes legally enforceable thereafter. This is the final step of the divorce process. The actual hearing itself should take about 10 to 15 minutes. The judge will begin the proceeding by asking you to raise your right hand and to take an oath to tell the truth. You can put your hand down after saying "I do." You should be ready to answer the following basic questions, keeping your answers short, direct, and to the point. One question will be regarding your Florida residency. You may be asked if you and/or your spouse was a Florida resident at least 6 months prior to the filing of the divorce as required by law. You can simply answer yes as applicable. You may be asked why you're seeking a divorce. Florida law allows a divorce where at least one of the parties or the spouses believes that the marriage is irretrievably broken for any reason in your discretion. Again, keep your answers short and simple. Answers such as "we don't love each other anymore" or "we don't get along" or "the relationship is broken" are legally sufficient. If the judge asks if you believe the marriage counseling would assist you with avoiding divorce, you can simply answer no, as applicable. The judge may ask you to identify whether there are any minor children who were born or adopted during the marriage and confirm whether the female spouse is pregnant or not. If there are any minor children, the judge may confirm whether the spouse has completed the required parenting course and affidavits. If a name change is applicable, you can take this opportunity to restore your maiden name if you wish to do so. Please tell your attorney prior to the hearing to ensure that this is properly done during the hearing. If so, the judge will confirm whether you are eligible for that name change for divorce purposes and not being changed for other illegal purposes, such as to help you commit fraud. For example, the judge may ask if you've ever been charged with a crime or ever been required to register as a sexual offender. They may also ask whether there's any money judgments against you, or if you've ever filed for bankruptcy, or whether your civil rights have ever been suspended, etc. The judge may review the actual settlement agreement to confirm your signature on the agreement and whether you signed the agreement freely and voluntarily without any duress. Again, just simply answer yes as applicable. The judge may also ask whether you still desire a final judgment for dissolution of marriage, i.e., the judge is asking you if you're still sure about getting a divorce pursuant to the settlement agreement. You can simply answer yes, again, to these questions as applicable. The following is an example of the actual questions that are normally asked in a final hearing. Do you swear or affirm that the evidence you are about to give will be the truth, the whole truth, and nothing but the truth? You put your hand down after saying "I do." Please state your full name for the court. You answer. What is your spouse's name? How long have you been married? How long have you been a resident of Florida? Is your marriage irretrievably broken? Do you have any minor children? What are the names and dates of birth of the minor children? Are you currently pregnant or is your wife currently pregnant? Did you and your spouse enter into a marital settlement agreement and/or parenting plan on whatever date it was signed? Did you enter into this agreement freely and voluntarily? Does this agreement resolve any and all issues regarding the marital assets and liabilities and the minor children? Is there anything left for the court to decide? Are you asking the court to order that you and your spouse abide by this agreement? Are you asking the court to enter a final judgment dissolving your marriage? Your attorney will be able to handle the remainder of the proceeding as needed. Again, if you have any questions or concern as you review this information, please don't hesitate to contact your attorney to discuss these concerns as soon as possible, preferably before that court hearing. Such issues can usually be quickly resolved prior to the hearing, And if not, it may be simply best to postpone the hearing until the issues can be resolved. If any problems do arise during the hearing, just stay calm and polite. Keep in mind that your attorney can ask that the hearing can be postponed to a future date to allow more time to resolve whatever issues have arisen, and then you return to conclude the hearing at that later date. Finally, if you're interested in learning more about this final hearing process, please tune in to my other video about other important tips for preparing and attending your final hearing in your uncontested divorce case. I hope this short video provided you some general guidance about the questions that are normally asked during the final hearing for an uncontested divorce case. Thank you again for joining me today, and as always, stay informed so you can stay strong.